Today we're taking the dense legalese of the Indian Contract Act of 1872 and turning it into your absolute strategic survival guide for commercial agreements. Think of this as a comprehensive legal research study on the key provisions that actually get invoked, incorporated, negotiated, and heavily litigated in Indian commerce. Our goal today is to give you the clarity you need to genuinely protect your business. So ask yourself, when a commercial deal completely collapses in India, which contract clauses actually hold up in court? Let's dive right into this, because let's be honest, a contract is really only as strong as its ability to survive a real-world dispute. You might look at a document and think, oh, this is ironclad, but until it's pressure tested against the statutory rules and judicial interpretations of the Indian Contract Act, you could be leaving yourself incredibly vulnerable. To get you that clarity, we've distilled our research into 5 critical sections for today's explainer. First, interpreting the fine print. Second, restrictive covenants and trade. Third, surviving force majeure. Fourth, calculating damages and penalties. And finally, limiting commercial liability. All right, let's kick things off with Section 1, interpreting the fine print, the rules of the game. Now, what's really fascinating here is how Indian courts actually read the words you put on the page. It's kind of like a progression. First up, the literal rule. If you haven't explicitly defined a term in your contract, the court is just going to use its plain everyday meaning. But what if reading it literally creates a totally absurd result? Well, then courts shift gears to the golden rule, which lets them look at the overall context of the document. And if people are still arguing over what it means, they use purposive interpretation. That's where the judge basically steps back and asks, okay, based on the context, what was the fundamental objective these parties were actually trying to achieve?
And this leads us to a huge red flag regarding exclusion of liability clauses. If your exclusion clause is even slightly ambiguous, courts will read reasonability into it, and they will almost always favor the party who didn't hold the pen. You know, the contra preferencem rule. So the big takeaway here, draft with absolute cautious precision. Interestingly, though, you can actually draft a clause that explicitly tells the court not to consider who drafted the contract, effectively turning off this whole interpretive mechanism. Pretty neat trick, right?
Moving right along to Section 2, restrictive covenants and trade, specifically navigating Section 27. Now, Section 27 fundamentally prohibits agreements that restrain trade. But there's a really brilliant, strict dichotomy here. Check this out. Restrictions during the lifespan of the contract trigger a reasonableness analysis, but restrictions after the contract ends are almost automatically void. Basically, if your non-compete applies while someone is actively employed or while a joint venture is ongoing, the court just checks if it's excessively harsh. If it's reasonable, you're good. But the exact second that contract terminates, boom, almost any restriction stopping them from working is strictly void under Indian law. So context is absolutely everything here. A non-compete clause that perfectly protects a massive commercial joint venture could be thrown out in 2 seconds if you try to use it against a former employee. Why? Because in an employment context, Indian courts fiercely protect a person's fundamental right to earn a living. Post-employment non-competes are pretty much dead on arrival. But in a purely commercial context, like M&A deals or franchise agreements, the courts are way more liberal. They get that you need to protect sensitive, proprietary commercial info and goodwill, so those are viewed much more favorably. All right, let's jump into Section 3, surviving force majeure, when the unexpected hits. With all the recent global supply chain chaos, you might look at this and assume, hey, an armed conflict? That's an automatic get-out-of-jail-free card for my contract. Well, under Indian law, that is a very dangerous myth. Take a landmark case involving land requisition during wartime. The Supreme Court essentially said that just because a war breaks out, it doesn't fundamentally change your obligation if that war was already something the parties could have contemplated. The impracticality has to strike at the very root of the contract.
And this brings us to the famous energy watchdog case. Imagine fuel prices suddenly spike because of overseas regulatory changes. The Supreme Court ruled that mere commercial hardship does not equal force majeure. In that specific case, power companies tried to argue that crazy increases in Indonesian coal prices made their long-term contracts impossible to fulfill. But the Supreme Court completely rejected that. They laid down the law. If alternative modes of performance exist, even if they cost you an absolute fortune, that does not defeat an impossibility claim. Section 56 is about true legal or physical impossibility, not just losing money on a bad deal.
Honestly, understanding this legal difference between objective impossibility and a severe economic burden, that alone can save your business millions. Force majeure means performance is entirely prevented, which can lead to a complete discharge of your obligations. Hardship, on the other hand, just makes it excessively onerous to perform. Here's the kicker. Indian law doesn't even recognize hardship as a standalone excuse separate from force majeure. If you want protection from wild price fluctuations or severe economic burdens, you literally have to explicitly draft price reset or renegotiation clauses right into the contract yourself. The court won't save you.
Let's pivot to Section 4, Calculating Damages and Penalties. This is the big battle between Section 73 and Section 74.
So when the mine actually goes off and the contract gets breached, the Act splits the financial fallout into two distinct paths. First up, Section 73, Unliquidated Damages. If you didn't agree on a specific penalty beforehand, you claim these. The court steps in and assesses compensation to put the aggrieved party in the position they'd be in if the contract had actually been fulfilled. But there's a huge catch. It only covers actual, foreseeable damages. You cannot claim for some bizarre, unpredictable chain reaction of indirect losses unless the other party explicitly knew about those special circumstances on the exact day they signed. Then we have the other path, Section 74, Liquidated Damages. This is when you pre-estimate the damages and write a specific number right into the contract. It was designed to cut through complex common law rules. But, and this is a massive but, Indian courts will only enforce that number if it is a genuine, reasonable reflection of the actual loss. It cannot just be an arbitrary punishment. The number you put in the contract, that's just the ceiling. You're still only going to get reasonable compensation up to that capped amount. This quote from the Supreme Court in the famous Fateh Chand case really hits the nail on the head. It's a stark reminder of India's strict rule against penalties. You can't just write a massive, terrifying number into a contract just to scare the other party into performing what lawyers call in terra rem and expect the court to blindly enforce it. Even if your contract explicitly says this massive sum will be forfeited on breach, the court actually has a statutory duty to step in, ignore the penal nature of that clause, and only award what is functionally reasonable.
Which brings us to our final stop, Section 5, Limiting Commercial Liability Through Strategic Protection.
So, how do you proactively build shields into these agreements so you aren't left totally exposed? Well, one of your most powerful tools is the indemnity contract under Section 125. Unlike the regular damages we just talked about, indemnity claims don't have those same strict statutory limitations on foreseeability. This means you can potentially recover all damages within the scope of the agreement. Basically, the risk of liability completely shifts. With a normal claim, you have to prove the breach and prove the loss was foreseeable. But with a tightly drafted indemnity clause, you force the other party to simply protect you and pay for the liability that arises, often regardless of how remote the causation is. It is a total game changer. Let's wrap this up with some highly practical guidance to mitigate your risk. If you follow these concrete steps, you ensure your actions actually align with these strict expectations of Indian courts. First, scrutinize your force majeure clauses for specific thresholds. Does the event need to entirely prevent performance, which is a super high bar, or merely hinder it? Second, know the difference between true impossibility and mere commercial hardship. Third, if things go south, issue prompt written notices with rock-solid evidence of the delays. And finally, and courts love this, actively pursue alternative supply sources to show you acted in good faith to mitigate the loss. You absolutely have to document that effort.
So we leave you with this question. Your contracts might look absolutely ironclad on paper, but are they truly built to survive the intense scrutiny of the Indian Contract Act? We hope this explainer has given you the strategic foresight to go back, review your commercial agreements, and ensure they're actually protecting your business when it matters the absolute most. Because knowing what a judge will throw out, whether that's a post-employment non-compete, a claim of economic hardship disguised as force majeure, or some unreasonably massive penalty, that is the real secret to drafting agreements that survive the real world. Think about it. Until next time, keep learning, keep adapting, and keep those contracts airtight.